right, thank you. Thank you, Travis. Appreciate the introduction.
Yeah, thanks. We feel like I'm right at home now. I've got a big screen TV. If you just put on the football game, I think we'll be ready to roll here.
Okay, perfect. So my name is Derek Brandt. I'm the Attorney General for the state of Utah. And, you know, it's interesting. One of the things that I get asked, probably more than any other question, truly, is what do I do as the Attorney General? And what's funny is the number of people who are attorneys who ask me that question. Now, our legislators don't ever ask me that. They know that. And I've seen, there's a bunch of them here. We've got Senator Winterton, Representative Chu. I know Representative Watkins is here, Representative Jack. And we have former Senator Redge. And is Steve Lund here too? Former Representative Lund. Thank you for being here. So they never ask me that, but I get asked that on a regular basis. What do you actually do? And it's funny when an attorney actually asks me that. The scope of the issues that we deal with, obviously we're going to talk about energy-related issues, but the scope is just mind-boggling. So just to give you an idea, I have about currently 310 attorneys in the office and about 600 people total, and that makes us, for those of you who are lawyers, that makes us the largest law firm in the state. By quite a margin, actually. We're the largest law firm. We have attorneys that deal with every conceivable area of the law. We have, I mean, literally, we had a hearing in front of the Senate where I sort of joked about the fact that we do everything from roads to condemnations to hunting license to child protection to prosecutions, and I sort of joked about the fact that we don't do maritime law. That's like the one area. And at the end of my hearing, my administrator came up and he tapped me on the shoulder. This is John Dougal. And he said, hey, just so you know, we actually do have a maritime case. So we do have a little bit of everything. We have a group of almost 30 attorneys who work with the Division of Natural Resources. A couple of them are here. There's Gary White right in the middle. Wave high, that's Gary. And then Carter is also here with him right over there. So they deal with a lot of these issues. So if you haven't met them, be sure to go and say hello to them. But literally, we deal with everything under the sun. Some of the things you may have heard about recently that actually don't involve energy and development are some of the lawsuits that we have filed against companies like TikTok or Snapchat. I had a pretty groundbreaking settlement and lawsuit a few weeks ago against the owning entity of Pornhub, and we really have forced them to change their business model worldwide, starting here in Utah. And so those are the kinds of cases that we get involved in. We also defend a lot of the lawsuits that are brought against the legislature for bills that they pass. So if they have a bill that involves energy, I mean, you name it, any kind of energy bill that they pass, we defend. In fact, there was a funny one just a couple of weeks ago. I was at the Supreme Court, and we were defending a bill by the legislature involving the constitutional right to hunt cougars. How many of you actually hunted cougars, by the way? And it's not a trick question. This is, and as a graduate of BYU, I was a little torn because if we're successful in defending the appeal, there will actually be less cougars in the state of Utah. So there's a little conflict there. But we dealt with cases like that. And we had so we also manage all of the criminal appeals for the entire state. So that gives you an idea of the size and breadth of what we do. Another thing that we do is I spend a lot of time working with other state attorneys general. The attorneys general around the country have shifted their view and their influence in the last 10 to 15 years. Because, as you know, Congress, as much as I love our members of the Congress here in Utah, they don't do a whole lot because they argue a lot, and then occasionally they'll pass something. But when was the last time you heard Congress, pass a bill substantively fixing a problem? It's pretty rare. So what it does is it leaves it to the states to fill in that vacuum. And so we do that. And so you see a lot of litigation involving various states. So one of the ones that we're involved in right now is a law that was passed, and you may have heard about this, in New York called the New York Climate Change Superfund Law. How many of you have heard about that? Okay, almost no one. This is one to look up. I know Representative Jack, he knows about this. And try not to scream as I discuss it, because this is This is crazy making. What they did is they passed a law that said any company that, and primarily directed at fossil fuel energy companies, but it said any company who took actions to exacerbate climate change between the years 2000 and 2024 will be retroactively assessed fees and fines totaling upwards of $75 billion. So think about that for a moment. Think about what that does. Think about the dynamics. I mean, in other words, they couldn't get a judgment in a court of law, so they went to a receptive legislative body who passed that bill. And so I am currently, have authorized Utah to join as one of the litigants with a number of other states fighting that bill. Because if you can sort of run through where that goes, it's very problematic. Vermont has done the same thing. So we are a litigant challenging Vermont's ability to do that. And other states are looking at doing the same thing. I know California, Oregon, some of the Midwestern states. So there are a lot of those kinds of cases that are out there. And one of the things that I like about what Redge and I have had a chance to do is the last 9 months, the dynamics are just, from a political standpoint, are entirely different. We have an administration that doesn't view energy development as an evil and take every effort to kill it. They're actually working with us. And literally from day one, it's almost been startling because, I mean, from day one, the president issued an executive order entitled Unleashing American Energy. And we have certain regulations that are imposed on us here in Utah. And they've been willing to work with us. I mean, 2 weeks ago, Redge and I were in D.C., literally sitting in the White House, Department of Justice, meeting with them on these kinds of issues, trying to figure out how is it that we can best navigate the idea of creating energy development here in the state. And as one interesting example, the head of EPA, Administrator Zeldin, came out, I don't know, it was probably 4 or 5 months ago. One of my biggest issues that we have as a state is what's called a 179B guidance document, which is part of the Clean Air Act, and it basically says, look, we're going to make you non-attainment unless you can prove that their ozone that is coming in is coming from foreign countries, and you have nothing to do with it. They made it really hard, so hard, in fact, that we figured that if the Salt Lake Valley had literally no one in it except cows, no, probably not cows either, right? Not cows. No one in it, if this were Mormon pioneers in 1847 filing their 179B guidance, it would be denied by the federal government. I mean, literally, there was no way we could ever get to attainment status. So here's what's cool, is the administrator of the EPA comes in, we meet with him in the Capitol. One of the first things we wanted to talk about was this guidance, and he literally, before we even said anything, said, just so you know, I rescinded it this morning. I was like, I grabbed my phone, I was Googling it. I'm like, did he really? And sure enough, there was a Google, article about how he had just rescinded it. So anyway, long story short, it's nice to have an administration that's willing to work with us. We have countless lawsuits that we're working with as an office at any given moment in time. And so our job as the attorneys in the Attorney General's office is to work with the state, represent the state, and make sure that we do a good job for the state in terms of opening up the kinds of energy development that we need as a state. So with that, that's just the short version of what we do in our office, and I'll let Redge talk about what he does at Politico, because we actually work a lot with, we are kind of tied to the hip on some of these really critical lawsuits.
Thank you, Attorney General. It's great to be here with you. I'm the director of the Public Lands Policy Coordinating Office, and it wouldn't be a good government organization if you didn't have a really long name and a terrible acronym like PLIPCO, but that's us. So what do? We organize or coordinate with all the different state agencies, so Department of Ag, DEQ, all the agencies in DNR. Then we coordinate with the counties, and we coordinate with the legislature, and we coordinate with our congressional staff. And we are the agency, we are unique in the Western U.S. In fact, we're unique in the U.S. But we help the state speak with one voice. What was happening before our office was set up is if there was an oil and gas lease, let's say, in Division of Wildlife Resources would send their comments in, and DOGM would send their comments in, and UDAF would send their comments in, and the feds would look at them and they'd say, okay, well, this is the direction we want to go, so that's the comment letter that we're going with. So our office is tasked with making sure that everybody in the state, all the state agencies are represented, but also that the intent of the legislature is there, that the intent of the governor is represented, and the intent of our congressionals are represented. So we also work a lot with the legislature on different bills. We work with our congressional staff on different bills and different efforts. So that's our work, I guess. We also work with industry a lot. If you've had a problem getting a lease, we may have been there at your back trying to get those leases done. We have some leases down in East Utah that were litigated by SUA and others, and we joined the fight there. So about half of my staff are policy people that work on the legislation, things like that. The other half of my staff are attorneys, and that's where the Attorney General and I are linked at the hip, and we do a lot of great work together. And I can't tell you enough how much the Attorney General office does for all of you, for all of us as citizens. I'm a 6th-generation Utahn, and I've been in this fight since I was a kid, literally. My dad's been in this fight for a long time, grandparents, great-grandparents, so I love the work I get to do. So I'm gonna hop in just a little bit and give us a background of kind of where we are. So starting off, I'm going to go back to FLPMA. FLPMA is the Federal Land Policy Management Act, passed in 1976. The map on the left, these are BLM lands. The map on the left shows you that every single acre of BLM lands in 1976 were open for multiple use and sustained yield. So if we had critical minerals out there, if we had oil and gas out there, if we wanted to recreate out there, we wanted to have grazing out there, they were all open for that. The map on the right with the purple on it is what's happened since 1976. They changed the rules on us. Half of those lands in BLM, or controlled by BLM, are now restricted from multiple use in one way or another. You have wilderness areas, wilderness study areas, lands with wilderness characteristics, areas of critical environmental concern, national conservation areas. I mean, the alphabet soup goes on. And what our office has been tasked is we're drawing a firm line. You wonder why, if you've ever talked to people in other states, why does Utah litigate on everything? Why does Utah fight so hard when, on public lands and these issues? That's a good story right there to tell people of why we're fighting so hard to protect what's left. So we're going to talk a little bit in a minute about the public lands rule.
Can I mention one thing? I gave a presentation a couple of months ago to a group of attorneys general across the country, and I mentioned that roughly 2/3 of our state is effectively controlled by the federal government. And I had an attorney general from the East Coast come up to me afterwards, and he literally said, you know what's funny? When you were talking, he goes, Derek, it sounded like you said 2/3. What is it really?
2/3.
It's 2/3. They have this is a completely different frame of mind for anybody really east of the Mississippi. This is they don't get this concept.
Yeah. Which is why we have to speak with one voice as a state. We all have to get together so that we're effective when we're talking with our federal partners, and especially with DC. That's where it becomes really effective. So the next map that I wanted to share with you is the roadless rule. So the first one was BLM. This is Forest Service. So it may be hard to see, but can you see the two different greens there? The lighter green is areas that are what the Forest Service was set up for. Water, timber, grazing, those kind of things. Roadless rule was passed by the Clinton administration, and that really restricted what we can do in the forest, especially when it comes to forest health, catastrophic fire. You all out here in the basin have had some really severe fires, filled this basin with smoke, et cetera. So this is what roadless rule looks like. I took my kids on a horseback trip up on the Manti La Salle, and as we were going up there, I noticed the conditions of this forest, and I said, is this a roadless area? And got back to the office, looked it up on the maps, and sure enough, I knew it was just by the health of the forest, right? You look at that. Now, ironically, there are roads all through that ridgeline right there. There was old logging roads that are there, but we can't use them because of the roadless rule. So everybody thinks these roadless rule are these pristine areas that have never been touched, similar to wilderness. And nope. There's roads all over in them, but we just can't use them to go in and do sustainable harvests of our forest, reduce the fuel loads, and do proper management. So thank goodness, the Trump administration is rescinding the roadless rule. We have a lot of people out there fighting us on the roadless rule, and it's not just the environmental groups. We have a lot of hunting groups and fishing groups that are like terrified that we're going to rescind the roadless rule. I want to just let everybody know, we're rescinding the roadless rule. The state of Utah is requesting in the state of Utah we rescind the roadless rule, but that doesn't mean all these roads are going to be opened up for, for everybody to just go out and willy-nilly use them. What we want to do is make sure that we use them responsibly, that we go in, we do the proper forest management. Yes, we are going to open up some roads for recreationists, for OHV folks. Where I grew up down in southern Utah, the Boulder Mountain, there's some great roads that go off, and you can look all the way to Arizona. Sure, we're going to open up a few of those roads, but we're not rescinding the roadless rule so that it just, we make new roads everywhere and develop it. That's what you're hearing from the opposition. That's what our intent is. That is not what our intent is. We want good forest management, but we cannot do that with the roadless rule. So we want to rescind the roadless rule. We want to do good forest management and be able to enjoy our forests. This next one, I think many of you heard Senator Lee's bill and the One Big Beautiful Bill talk about selling off public lands. The Wilderness Society said, oh my gosh, they're going to sell every acre of public lands. So the map on the left is what the Wilderness Society said. These are all the acres that are going to be sold off for public lands. And their map was all west-wide, but I'm just focusing on Utah because I know it better. The map on the right, how many of you can see the red in there? That is the lands that were actually qualified. So on the left is what Wilderness Society told you was up for sale. On the right is what was really in the bill that would have qualified under the language. So that's about 22 million that the Wilderness Society told you we were selling, or the federal government was selling off. It's about 65 million, or 65,000, excuse me, on the right. Sorry, trying to make sure I'm getting the directions correct there. Of those 65,000, though, knowing these lands as well as I do, there's about 7,000 or 8,000 that's actually buildable, that's close enough to utilities and things like that. So 22 million versus 6,000 to 10,000 is what the state of Utah is really interested in. So what do those lands look like? That's what the public lands that we're interested in look like. This particular parcel's in Washington County, surrounded by three sides by homes already. This one's in Beaver County, just right off the freeway. You can throw a rock and hit the freeway here. So those are the kind of lands that we're talking about. So why is this important? If you saw in the Big Beautiful Bill, there's some great language about oil and gas and being able to get out on these public lands and finally do some exploration, finally be able to do some production on these public lands so that we can become energy independent. Well, just yesterday, the Wilderness Society, so remember the Wilderness Society map, just yesterday the Wilderness Society map came out and they said, this is what is going to be allowed for you as oil and gas producers. You're going to be drilling on every acre of the West. This was their map. Now, if you know the basin, you know Utah, we don't even have resources in these areas. So it's a big scare tactic, right, about what they're trying to do, or what you all are trying to do, what we're trying to do, what the Trump administration is trying to do to become energy independent. So these are the kind of things that we're constantly fighting back on with social media, educating people, those kind of things, policy work. So that's a little bit about our office, and we can get rid of the slide deck and go on to our discussion about litigation.
Well, and the ultimate goal here, obviously, is to create the energy that not only that we need, but that we are going to need. So the irony is, at the very moment when our energy needs are going to be a multiple of what they currently are, we have groups that are doing everything in their power to make sure that we can't develop the energy that we need. So it used to be, and Redge, chime in here, but it used to be that energy development, exploration, and the creation was an issue of economic development. It was an issue of jobs. It was an issue of being independent from foreign actors who didn't have our best interest at heart, that sort of thing. That has all completely shifted now. It is more, in many ways, it's an issue of national security, because, as you know, the world of AI is developing in such a way that our power needs are increasing exponentially. And what's really interesting from my standpoint is at the very moment when we really should be just opening up the floodgates. I mean, let me give you an example. I mean, I don't know how many of you use, say, ChatGPT. If you use ChatGPT for a more comprehensive search than just a Google search, you're using anywhere from 30 to 80 times the power that you would otherwise use. To develop and roll out a frontier AI model, over time, that will cost the amount, or that will use the amount of energy that it would take to power several thousand homes. I mean, the amount of energy that we need is monumental. And it's an issue because so many of our systems, our intelligence systems, our defense systems, our economic systems, are a function of energy. We need a multiple of that now and in the foreseeable future. And what's interesting is at the very moment when we need that, we have these groups doing everything they can to shut it down. And this is one of the things that we've been fighting as a state, is the idea that, I mean, let's upgrade coal-fired power plants, but the upgrades are so expensive that it makes more sense to shut them down. I know Representative Jack could probably give a whole lecture on this very issue because it's the world you deal with. But one of the things that's interesting from my standpoint is that at the very moment we need this, we're being fought left and right. And if you look at what they're doing in China, if you want a frightening ChatGPT search what they are doing in terms of energy development and production. I mean, when was the last time we built an energy plant around here?
Decades.
Okay, China permits and on average completes one coal-fired power plant. How often? Who knows the answer? I heard it. Who said it? 21 days. And I've heard that it's even shorter than that in the last year. They're currently developing 6 to 7 nuclear plants. So China gets this. Now, obviously, there are environmental issues that they probably just ignore as they build these things, but they understand the needs. They understand where we need to go. They understand why this is important. And so from my standpoint, we need to do everything we can to ensure that the state of Utah has what it needs, not just for our own energy development, but for the energy development around the country and you know, from a strategic national security issue.
Yeah, I just want to hop in. I've been out on a lot of your sites. I've been on to a lot of mine sites. We do things responsibly. You all as producers are responsible producers out there with the landscape, with the products that you're doing. The mines are the same way. One of our biggest coal mine, the Sufco mine over by Salina, the whole footprint's like 45 acres, right? It's mostly underground. You don't even know it's there. However, you have groups like Center for Biological Diversity and Southern Utah Wilderness Alliance and all of these crazy groups out there that are litigating us to keep us in the dark ages. And I would like to be able to just shut their phones off, shut their computers off, shut their power off, and see how long they survive without all of those resources, because you all are the ones that keep us in the modern economy. And I can't tell you how much I appreciate it. You're the ones that keep my truck full. You're the one that heats my house in the wintertime. You keep my lights on. So for me and for my team, I want to thank you for all that you do. And I'm telling you that the two of us, we're here to fight like hell against all these environmental groups that are trying to block us at every turn and keep us in the dark ages, quite literally, if they could. So that's what we're here for.
Discuss a few cases that more recent cases. Is that,
yeah,
you want to do that? I mean, one of them that I was just thinking about this because we mentioned it's not just some of these NGOs and groups that are doing it. I mean, there's also a bureaucratic mass. Think of the mid-level managers in the federal government who do everything they can to make sure that nothing happens. And so you have laws like NEPA, which we can talk about NEPA, who, you know, it was, I think, passed with the good intention of making sure that you analyze an environmental impact, but it's been converted into the all-purpose tool to stop anything and everything from being developed. And then we have here in Utah, the Good Neighbor Rule is an EPA rule, and it required states to put together what they call state implementation plans, or SIPs. Many of you know what that is. And so as a state, we spent a lot of time and energy putting together our state implementation plan so we wouldn't be declared in non-attainment status. And about 22 states did this, and the federal government, the EPA specifically, looked at all of them and basically didn't look at them and just said, you know what, we're going to reject them all. So we challenged that in the 10th Circuit here in this area of the country, and the EPA said, no, what we'd rather do is challenge it on our home turf in the DC Circuit. So this was an important case, because if we're going to challenge these kinds of things, as a lawyer, you understand this. Sometimes where you challenge a case, where you bring the case to bear, has everything to do with your chances of winning. I won't call it the home game rule sort of thing, but I wanted to challenge these here and not in DC. So together with Oklahoma, who's also in the 10th Circuit, we filed a case at the Supreme Court. They granted what's called certiorari. They heard this case a couple of months ago, and we had our Solicitor General and that from Oklahoma were in the Supreme Court chambers. We argued this case, and we won an 8-0 opinion just a couple of months ago. So these kinds of cases will now be heard here on the home ground. Now, this is sort of a geeky jurisdictional thing, but as you know, where you file suit has everything to do with your chances of success. And so those are the kinds of things behind the scenes that we're doing. So we've now set the stage that for additional challenges of this nature, we can do it here. But on NEPA, do you want to talk about any of the, we've got some great NEPA cases as well.
We do.
Involving right here.
So 7-county infrastructure, right? The Uinta Rail case. I have a mea culpa on this one. When we got rejected by the DC court and they said the NEPA wasn't sufficient and we didn't do the downstream analysis correctly and all that, we had been dealing with losses on NEPA for a long time. And we have had to go back and do NEPA. My shop, the policy guys, they do a lot of the NEPA. Then when we have to challenge NEPA, that's when we partner up with the AGs and we challenge the NEPA in litigation. And it just had not been going well. And my recommendation to 7-county was, you know, 7-county, you might be better off money just going back and redoing the NEPA and not trying to get to the Supreme Court. I don't think there's much of an opportunity to get to the Supreme Court. Boy, was I wrong, and I got to own that one. I am so glad 7-county, Keith, I think you were in the back earlier. I'm so glad that you guys pushed forward with that. Once they decided they wanted to go to the Supreme Court, my team got all behind them, and we did everything we could for them, but my advice was not right on that one, and it has been a game changer. We're seeing this case throughout the West being used, cited to, but do you want to give a little background on some of the quotes from the Supreme Court?
Yeah, I mean, this is, how many of you are familiar with the 7-county case, just by the raise of hands? Okay, good, that's a good group. So for those of you who aren't, just the very brief, the factual pattern is obviously we've got a railway here that we're trying to connect from the basin to the national freight system, and the way you do it is you go through, the Surface Transportation Board does a NEPA analysis. NEPA stands for National Environmental Policy Act. So the idea is before we have this bill that could have an environmental impact, we're going to do a study, and we're going to look at information. And so they did that, and it was roughly 200 pages long, yep. Right? I mean, so they literally looked at everything from mosquitoes to warts. I mean, they looked at everything. The Surface Transportation Board, after looking at it, approved the rail. Everyone was happy, except the left-wing groups that brought suit and said, well, actually, you didn't analyze here in the basin the environmental impacts, not just on increased drilling here, but the downstream effects in places like the Gulf Coast.
And from the Gulf Coast, when it gets exported, what were the costs exported, right? So it was not just even in the United States. It's like, we've been dealing with this for a long time. They call them the downstream effects. We were supposed to analyze and tell the end user in some of these cases, and it was becoming ridiculous. We had these court cases that were, you know, these activist judges were trying to push this narrative. So the analysis or the court came back, 8-0 decision, which you guys know that the court's pretty split, and you rarely get unanimous decision. One of the Chief Justices recused himself from the case, otherwise it would have been a 9-0 decision. So a phenomenal decision, and
this has implications for not just a railway here, but across the country, because NEPA is the tool by which groups stop anything and everything from being built. There are other projects here in Utah we're working we're working around the clock to try and get built. NEPA's always been the way that groups stop it because, I mean, think about it. If you have to analyze here in the basin the downstream effects in the Gulf Coast, I mean, how is this going to impact the climate in Louisiana? What you're really saying is you can never really know that. So there's it's setting it up so you can never actually get the approval. You're always giving some bureaucrat a justifiable reason to say no.
And I also add to that it was giving these environmental groups a win every time they went to court because they could pick something out in NEPA, this one small section that hadn't been properly analyzed, and then they would not only win the case under EJA, the Equal Access to Justice Act, they were using taxpayer money to pay them to go back out and sue again. So it was this whole cycle of terrible process and law that was occurring. And the Chief Justice finally put an end to that. I got to read a quote. This is from Chief Justice Brett Kavanaugh with the majority opinion. NEPA is a procedural cross-check, not a substantive roadblock.
Okay, say that again. Can we cue music? This is where like as a geeky lawyer who does, I love this. Say it one more time. Because I'm going to be quoting this for the next forever.
NEPA is a procedural cross-check, not a substantive roadblock. That is exactly what NEPA was for. It was just to analyze if you build a project, you build a dam, you do a forest management project, what was the impacts? And if there are a number of alternatives when you do NEPA, usually 3 to 5. And you're just supposed to say, okay, here's the impacts, this is what could happen if you do this, this, or this. But it was never intended to be used as a tool to block these projects from happening, and the Supreme Court finally gave us that ruling, which, thank you, Uinta Basin, thank you all that were involved in that case, because you have helped the entire nation move forward where we can finally build things again and finally do proper management, so thank you.
Well said. I mean, this will be cited for years to come. There was another case, the last Supreme Court session, that is sort of a companion case to this. It was a case called Loper-Bright, and this deals with what's called the Chevron deference doctrine. And how many of you have heard of Chevron deference? Oh, this is great. So I don't even need to explain what it is, but I can tell you I hated it. This is something I learned about in law school 30 years ago. And it stems from a 1986 case involving the NRDC, where the courts basically said, look, we're going to just let the agencies do their thing. They're really the experts. If they tell us something is so, we're just going to assume it's so. And so what that did for decades is it allowed Congress to not do their job because they knew that the bureaucrats would maintain the status quo and that they could accomplish their objectives there. And so if there was, and what it meant is if there was any sort of agency discretion, they just gave the agency deference. And there were so many of these cases involving building and not just NEPA, but anything across the spectrum.
I'm sorry, but if you've ever spent much time in Washington, D.C., and you go back into these buildings and you're talking to these folks that have never set foot west of the Mississippi, that have never been on a building project, never been on a well pad, never been on these projects, they were the ones making decisions for the rest of the country, right? And it was just a terrible precedence that we were giving all this deference to these D.C. bureaucrats who had never held a real job. They literally had never been outside their building or done anything to be productive, not to be productive, that may be a little harsh, but never done anything to produce something. So this was a huge case. This was,
and so the Supreme Court, again, a majority opinion said, look, this concept that we've had for literally, I mean, it was 1986 when the court started doing it. They said, look, we're going to roll that back. There are so many problems with this. If Congress can't get clear in terms of their language, then rather than just kicking it over to the agencies and letting them be the experts, well, maybe Congress should do its job. And if they're not going to do its job, then we're not going to give them the deference. And so, again, this goes back to the issue of Congress figuring out what their job is, doing their job. And if there's ambiguity, then we're not going to just let the agencies do. And you can imagine if the agencies can do whatever they want, I mean, this really helps the status quo. And if the status quo is we're not building anything, we're not extracting, we're not moving, we can't get anything done from an energy development standpoint, then this facilitates that. So anyway, this decision is, I mean, those two decisions alone completely alter the energy development landscape for the next couple of years. And so anyway, and then we've got a number on roads and access. Do you want to talk about some of the great victories you've been very involved with the last couple of months or decades as well?
I'm going to go really in the weeds for just a second and mention one more case, and that's the Marin County. And this is, if you ever anybody heard of the Council of Environmental Quality out of the White House? A couple of you. So this was a very powerful group in the White House, and they would affect policy for all of the agencies every time there was an administration change. They would come in and say, okay, everything in every department would change dependent on what they put out from the White House. So this was a very powerful group that would affect everything from energy to healthcare to public lands. And the Supreme Court ruled, ironically, the case was from Audubon, and it basically detoothed the CEQ. It said, you guys have been overreaching your statutory authority for decades. And so they said, you can no longer dictate to all these agencies what is going to happen. They're going to have to come up with their own NEPA policies, their own policies individually. So it was a huge change, because when the Biden administration came in, they would just completely roll back everything that the previous administration had put in, and it literally took, a few months. This is going to at least make it very difficult to change these NEPA processes, and with some of the work that we heard earlier, if we can get some statutory changes, we'll finally be able to get control of NEPA. So with what's happened with the courts, what's happened with the CEQ, what's happening in Congress right now, and even with some of the states, I think we're finally getting a hold of that regulatory burden that has really been choking us for the past couple decades. So, can I go on?
Do you want to go through the roads?
Yep.
This is, and let me just say, these roads cases have literally been going on for decades. And Redge and I, literally 2 weeks ago, were in Washington, D.C., meeting with the White House and the Department of Justice on this. And let me tell you, it is a whole different world to have a Department of Justice that is willing to sit down and, heaven forbid, we haven't seen this for a while, but have a conversation. You would think that that would be sort of a natural course of things. It isn't the case. But I have been so surprised, not just on roads, but I mean, we had a huge issue, I won't even get to the details, but involving the Department of Justice against Utah and the Department of Corrections, which was highly political. Within the first week of this administration, I got in touch with the Department of Justice, walked them through the issue, why it was going to cost us, they wanted to settle for $80 million or something ridiculous. And within a week, it got dismissed. So there are people at the Department of Justice who are empowered to make these kinds of decisions. And so it's just a night and day difference, and it's nice to be able to sit down. So do you want to talk about the roads issues we were discussing?
So by raise of hand, anybody heard of RS 2477 roads? How about Title V roads? I know a lot of producers use Title V roads. So Title V roads are renting from the federal government access to these public lands. RS 2477 is actually owning them like you own your house. So that's like the difference. So RS 2477, we've been in this litigation for well over a decade. And in fact, we've been just in the litigation, but the effort goes all the way back to when my dad was in the legislature 20-some years ago. They started working on this and got some early wins. But recently, we've had some really good results on RS 2477. Last August, not this summer's August, the August before that, Judge Waddups, who has been overseeing this case, ruled that Utah does, in fact, have title to the roads, and we have the ability to sign the roads. We have the ability to maintain the roads and enforce things on those roads. So, biggest decision that we've had so far, there are a number of things that we're going through right now. We have 12,000 roads that we're litigating on in the state of Utah. And we can't litigate all of them at once, so we've picked a number of roads and Garfield County and Kane County, we call that our bellwether case. And that's the ruling that Judge Waddups gave. But we have like scope of the road left. We have a few other things that we're trying to get that final ruling. We're hoping to have the final ruling from Judge Waddups here in the next 6 to 8 months at the most, hopefully sooner. We've been waiting for it for a while. But we've made more headway in the last year and a half on that RS-2477 issue than we have in a long time. So once we get that settled, the case settled, then we can start having discussions with DOI and others about the next steps forward on how we solve or how we formalize the 12,000 roads that we're looking at. We've already filmed most of them. We have testimony on most of them. We have evidence on most of them. So we're really looking forward to finally being able to put that to bed, because it's been a labor of love, but it's been a heavy labor over the last.
And can I add, just from a background standpoint, this goes back to I think it's 1866, when Congress said you could go across federal lands with roads. And in 1976, they basically said, look, if those roads have actually been used consistently for the last 10 years, prior to that, then the state can basically own them, maintain them, operate those roads. So and Redge and his team have been in the process of collecting. I mean, those of you who are lawyers, think about this. Who is it that can provide eyewitness or testimony about road utilization pre-1976? Or let me ask a different question. How old do you think those people are? And the answer is?
Old.
Yes, very. There aren't a whole lot of them around. That's why we're moving fast. But the reality is, and I got to read you a quote just so that you understand why this matters and why Utah being able to control these 12,000 roads under that law matters. Here's what the judge said, Judge Waddups, said that he alluded to that decision. And let me just read the quote. He said, if the United States effectively would gain control not only of the 8 jurisdictional roads, but also all roads that are significant enough for the U.S. to classify as open. In short, the United States will control the major roads. So this is just not a battle about a couple of roads. This isn't a couple of dirt roads in the middle of nowhere. This is a battle for the heart of who owns, maintains, and controls tens of thousands of roads across the country. And the fact that we have now gotten our first really impactful and positive decision from a federal judge, I think it's big. We've laid the groundwork, I think, now for a complete shift in where this is going.
So thanks for bringing that up. Some of these roads, RS-2477, they're actually paved roads. These are county-maintained roads. These aren't little 2-tracks like Southern Utah Wilderness Alliance would like to have you believe that they're cow trails and little 2-track roads that don't go anywhere. No, these are major county roads that we absolutely are critical for access. And let's also say, I don't care if it's a 2-track road going to nowhere. Sometimes I like to go to nowhere. I really enjoy being in nowhere once in a while. It's good to get away. So my team, we're drawing the line. We're trying to protect every single road out there in the state of Utah. Many of you probably saw over the last 4 years, they closed 2,000 miles of roads. Some of those were RS-2477 roads. This is just on BLM land through the travel management planning process. Our team is working on getting those reopened. I encourage you to stay tuned at 3 o'clock this afternoon from a BLM announcement. Can't say any more than that, but there's a little teaser for today. Looks like we got to wrap up fairly quickly here. I do want to say the state of Utah, the governor's office, you may have seen his Western Governors, he's chair now of Western Governors Association, and his initiative is Energy Superabundance. He has your back. As the governor's public lands advisor, I can tell you I deal with him all the time. He has your back. He wants to make sure that you're still producing. His latest quote, which I loved, it's time to build. It's not a time to shut down. And then he went on to say, we're not shutting down coal-fired power plants. We're not shutting down energy development. We're not shutting down gas-fired power plants. He says we need it all, and we need to get ready to go back to doing big things. And hopefully with some of these court cases, Loper Bright, thank you, 7 County Infrastructure, these great decisions that we have, hopefully in the future we're going to be back to building big things and doing great things for America.
And let me add, the building itself, much of the real building, the infrastructure building that we've tried to do has been stopped because of NEPA. And now, thanks to your case here in this county, where the court has said, I'll say it again because I just love it, NEPA is a procedural cross-check, not a substantive roadblock. For years, it has been the ultimate roadblock for building big things. And now we no longer have it as a roadblock. It's back to what it used to be. So on that note, Travis,
do we have time for questions, or are we done? Are we getting the hook?
We have time for one question. Is that what you said?
Okay.
I had one written down just in case we had time. Thank you. What do you anticipate for the remaining years of the Trump and Cox administrations as far as energy and public lands? Just really brief snapshot for the next couple of years.
Yeah, I'll start on that one. It's going to be really simple. Great things. That's all I can say. When I look at what's happening with they're rolling back the public lands rule, we litigated on that public lands rule, but now the administration's just going to be rescinding that public lands rule. That would have affected the other half of the BLM lands that we had. It would have kind of put those in a conservation category, a museum management look but don't touch. So that's huge. The roadless rule is being rolled back by the Trump administration. Another huge win for us. When I look at what the Cox administration is doing for energy abundance, deregulation, his current executive order on deregulation on the state level, and then his relationship with the Trump administration and especially with Secretary Burgum and Secretary No, not DOI, Department Ag. Name just went out of my head. Anyways, great relationships there. The coalescence of good things happening for Utah, I just can't tell you. I'm super thrilled to see what's happening right now.
And can I notice that as we're talking about building and growing and expanding into the next, century, notice how nobody's talking about technology? At least we're not. Because technology isn't the problem. The problem is the political and legal and the regulatory just roadblocks. And so the way I see it, just to plug what we do, I mean, some people say that, you're, as the Attorney General, you're the top cop or what. No, what I am is I'm the top legal officer. My job is to run not just the biggest, but the best law firm in the state. And all of you have worked in companies. If your general counsel or someone from the GC's office doesn't respond, or they respond really slow, or they're not good at their job, can you get anything done? The answer is no. And so my job is to ensure that we have the best law firm, the most effective and responsive law firm, because we literally represent the state in all of these efforts. And if we're doing our job and we're doing it well, then we can break through all of these roadblocks that have been put up. Because again, the issue and the problem is not having the ability to do it, it's having the kinds of legal counsel that do it. One of the cases that we're working on right now deals with small modular nuclear reactors, because under the NRC Act in 1954, the NRC has basically decided that their job isn't to facilitate or permit nuclear plants, it's to stop them from being built. So again, we have a lawsuit here in Utah where we're the plaintiff pushing through. So we are going to continue that kind of thing and ensure that we work with the administration and hopefully administrations beyond.
Thank you.
All right, I think that's it.
I think we only put one person to sleep, so I think we did a good job.
All right.